So Polly Murray, who is a brilliant legal strategist
Genius.
and a genius, and Ruth Bader Ginsburg, who was another
Genius.
genius, they used the 14th Amendment during the 70s to basically create a workaround for women's rights based on the 14th Amendment. And she always thought of it as a workaround. What is the downside of basically having our rights as women be founded on the 14th Amendment?
That's an amazing question. I think a lot of people who oppose the ERA sort of one of their go-to comments is, well, why do we need it? Isn't it already in the Constitution? Or through the work of Ruth Bader Ginsburg and other people like Polly Murray, don't we have something called a de facto ERA? Meaning, haven't we gotten to a place where we've, through the genius of these people, gotten the Supreme Court to acknowledge that the 14th Amendment actually also applies in the gender context beyond the race context, right?
Mm-hmm.
And it's not enough. And I think that the 14th Amendment also, the way that it's been interpreted in the recent decades, has really been used as a tool to undermine equality, unfortunately. One example that I can point to is that, during this horrific crisis of the pandemic, President Biden created a kind of like infrastructure bill that was meant to give some financial support to owners of businesses, restaurants. And part of this bill, it wasn't to give certain people more money. It was only to expedite the check. So for people who are from a historically marginalized group, so women, people of color who are business owners and restaurant owners, they would get their stimulus check a little faster than other people. So this provision of the infrastructure plan was challenged in the Sixth Circuit. And the judge in that case basically used the 14th Amendment as a sword in that case to sort of say, well, you can't create these provisions that treat people differently based on their gender. And so therefore, this provision that is meant to help people who have historically been disadvantaged and marginalized and perhaps in a worse place as a result of the pandemic, you can't treat them differently and you can't favor them in any way in our law. So the 14th Amendment has been used in the race context and also in the gender context to basically strike down measures that would affirmatively help people who have historically been marginalized. And so that doesn't help people. And this kind of viewpoint of the 14th Amendment as one of formal equality, meaning blind to race or blind to gender, is also blind to the inequalities in our systems, in our laws, and our infrastructure that has gotten us to this place of inequality, right? And so being blind to inequality when looking at laws is in a way an undermining of equality moving forward. So I don't think that the 14th Amendment is enough. And I think that we need a different way of thinking about equality. I think in other countries, they have adopted equality models that are a lot more robust, a lot more substantive, not just in terms of we protect, individual people from government action, from government laws that are meant to interfere with their rights. Rather, we see equality as the government has an affirmative obligation to support people, to restore people to a place of equality that they, have historically has been taken from them. So I think the ERA is very different from the 14th Amendment in that regard and has the potential to go beyond the 14th Amendment in ways that are, incredibly beneficial for most people in this country, I would say.